Welcome everyone to the Ray Law International channel. I'm Anthony Ray, one of the attorneys here at Ray Law International. While relationships are a lot of fun, some couples face challenges and difficulties. Being married for many years, I understand the joys and challenges you face. Unfortunately, not all relationships and marriages survive the test of time. In today's video, we'll discuss what happens when you seek to obtain a green card through marriage and then get a divorce.
How do you obtain a marriage-based green card?
A marriage-based green card is an authorization to live and work in the United States. Thus, the first step in the process is to become legally married. Before that happens, you should understand that there are various procedures in place to discourage fraudulent marriages that are entered into solely for the purpose of obtaining the green card. This includes extensive interviews, proof of authenticity in terms of the relationship, and in some cases, at-home visits by the USCIS. If you intend to apply for a green card by means of marriage, you will be required to undergo the required application processes. The stages are as follows: conditional resident, permanent resident, and then citizenship.
Do I need my spouse during the application process?
Overall, yes, you will need cooperation from your spouse along the way. Your spouse should be available to give required signatures, provide necessary documents, and answer questions should they be contacted by the USCIS. However, the level of involvement by your spouse decreases with each stage. The period of time immediately following your marriage is when you'll have to undergo the initial interviews that we mentioned. So, if you happen to get divorced prior to approval for conditional residence, you won't be able to attest to the authenticity of your union and will be prevented from moving forward with the process. If you've achieved conditional residence and are applying for permanent residency, you will also need cooperation from your spouse. If you aren't married at that time, you'll bear the burden of proving that the marriage was authentic by yourself. It is not impossible, but it is more difficult. Finally, if you are a permanent resident applying for citizenship, you won't have the need for the same level of cooperation from your former spouse. However, the general obligation to prove that the marriage was authentic still exists. That means if for any reason before you become a U.S. citizen, the USCIS has reason to believe that you entered the marriage by committing a fraud, your application can be denied, even at this end stage. The joining of two families through the union of marriage can be a wonderful thing, but life happens, and you should be honest with the USCIS if you indeed married with good intentions, but now find yourself no longer with your spouse. If you have questions about an immigration process, let us know in the comments below or send us an email. Now, more than ever, it is vital that you have an immigration attorney involved in your immigration case. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Stay updated on immigration matters by subscribing to our channel and sharing these videos with friends. Stay informed, stay educated, and until next time, stay on the right immigration path.